We have breaking news out of the United States Supreme Court this morning. In the case of Moren versus Liver, which is Massachusetts actually, the Supreme Court has granted cert, vacated a lower court anti-gun decision, and told the First Circuit Court of Appeals in Boston to get it right this time. Stay tuned. We'll go into the details. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, best-selling author, constitutional attorney, member of the United States Supreme Court Bar, and proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and feel free to share these videos with all your feeds and all your friends to the Second Amendment. All right, big news out of the Supreme Court today. Today, the Supreme Court issued a series of orders. One of them dealt with a case called Moren versus Liver. Now, Moren versus Liver should be entitled Moren versus the Commonwealth of Massachusetts. In this case, which the Supreme Court just slapped down essentially the First Circuit Court of Appeals in Boston for getting it wrong under the Second Amendment, what the case involved was Mr. Moren, who's actually Dr. Moren with a PhD. He had a license to carry guns in Massachusetts. About 10 years ago or so, he carried his gun to the District of Columbia without a license for D.C., brought it into a museum, saw a no gun sign, went to the police officer there, asked where he could check his gun since he's not allowed to bring it into the museum, and the District of Columbia Police Department arrested him for carrying a gun. He then pled guilty to a nonviolent misdemeanor, that he had a gun where he shouldn't have had it. Okay? Here's the issue. Under Massachusetts law, as of now, or at least over the last few years, if you had been convicted of a nonviolent misdemeanor, not a felony, a low-level misdemeanor, a nonviolent misdemeanor, that involved the use of or possession of a gun in any respect, then you are not allowed to get a form called a permit to purchase a gun. So you could get various other gun permits in theory, but you could not actually acquire a gun by buying a gun because you could not get this gun permit to buy a gun if you had that one low-level misdemeanor conviction. You were banned for life. I repeat, for life. No exceptions. So because he, asked to check his gun and was arrested in D.C. and pled guilty to a nonviolent misdemeanor in D.C. for carrying a gun. By the way, he had a Massachusetts carry permit at the time, but he didn't have one for D.C. So he pled guilty to a nonviolent misdemeanor, low-level misdemeanor, no jail time, nothing like that. But in Massachusetts, they would not give him a permit or a license or a document that allowed him to buy a new gun. And the First Circuit Court of Appeals, which is the Court of Appeals below the U.S. Supreme Court in Boston, said, look, this is constitutional under the Second Amendment for two reasons. One is you can still get a gun. For example, you can inherit a gun. So it's not actually a gun ban. Think about that for a second. Because you're not allowed to buy a gun, it's not a gun ban because you might be able to inherit a gun. So you might still be able to get a gun to exercise any limited Second Amendment rights that might exist, suggesting there is no Second Amendment rights, but we know that's not true. The second major mistake the Court of Appeals in Boston made was they applied intermediate scrutiny. Now, you know from this channel, if you hear anything like the tiers of scrutiny, intermediate scrutiny, strict scrutiny, rational basis, you hear any buzzwords like that, you go running for the hills. That is a euphemism. That is a metaphor for what? For balancing away your rights. It is an excuse, a door opening for a judge to balance your right to keep and bear arms on the one hand against the so-called usually fake interest, governmental interest proffered by the government that why they need to regulate guns. Supreme Court in the NYSERDA versus Bruen cases, that crap is tossed out, which is exactly what we talked about on this channel before Bruen. That is crap. That's not how the Constitution works. The balancing of interest was done by the Founding Fathers when they wrote the document. No court is allowed to second guess the Founding Fathers. If somebody wants to amend the Constitution, have at it. But until then, these judges are not supposed to balance away rights. And that's what NYSERDA versus Bruen said. But in the Moren versus Liver case, which is really Moren versus Massachusetts, so that's exactly what happened here. Down there in the First Circuit Court of Appeals in Boston, they balanced the man's interest to have a gun and his right to buy a gun under this law against the governmental interest to protect people from gun violence, which was a propaganda term. Gun violence doesn't exist because guns don't do anything without a person. So today, the Supreme Court looked at Dr. Moren's case and said, that's it. The First Circuit Court of Appeals screwed this up. We're going to grant your petition for cert. We're going to vacate and make irrelevant, make moot the lower court's decisions against the Second Amendment. No more. They no longer exist in American life. They have been vacated, null and void. And we're going to politely ask the First Circuit Court of Appeals and the Massachusetts courts to politely, this is how they phrase it, to reconsider their decisions in light of our precedents, including NYSERPA versus Bruin. Now, this is a nice way the Supreme Court has put it to saying, we're giving you back your paper. Now, we'd like you to go home and try again and come back and make sure you get the right answer this time. That's a polite way that remember, the Supreme Court is very professional. They're very polite. When you argue before the United States Supreme Court, they expect you to call your adversary friend. That's true. When an amicus curiae brief or amicus curiae brief, whatever you want to call it, okay, multiple pronunciations, I don't think it matters. Bottom line is this, that is called a friend of the court. So the Supreme Court is a very civil place and they expect high-level professionalism. They're usually not nasty, they're usually not impolite. So when they tell the Boston Courts of Appeals, when they tell the Federal Court of Boston, we'd like you to reconsider your prior decision in light of NYSERPA versus Bruin, that is a very polite way of saying, you messed up, you got it wrong, please go fix it and get it right this time. But we're not going to be nasty about it. We're not going to insult you. We're not going to embarrass you. We're simply going to say, get it right this time, please. So this is a very good sign that the Supreme Court thinks that these kinds of laws that prohibit people from exercising their right to keep and bear arms for nonsense reasons is a no-go zone. Now, we're going to talk about down the road what I think the future is for nonviolent felonies and whether or not they're going to be able to, people with nonviolent felonies on their record, whether or not they're going to be able to exercise gun rights down the road. We'll talk about that in a future video and where I think the Supreme Court's going to go on that. But for now, very good news out of Massachusetts. The Supreme Court has granted cert and given another victory to the Second Amendment, a polite one, and a reaffirmation of it. And again, good news. More good news is coming, I suspect, in a lot of ways, but this is good news as well. And good job, Dr. Moren. I hope you get all the remedies and relief that you want down there in Massachusetts. Okay, I hope you learned something here at the Four Boxes Diner. If you haven't subscribed, please do so. Again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.